Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. This week, the Supreme Court returns for oral arguments. In today's episode, we deliver final thoughts on these cases. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. And if you have any questions about the case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. Okay, let's begin with Chevron v. Plaquemines, which the Supreme Court will hear on Monday, January 12th. Let me start here with some late-breaking news. Justice Alito announced this past Thursday that he will not participate in this case. Justice Alito relayed this news through a January 8th letter from the Supreme Court clerk Scott S. Harris to the parties. The letter explains that Justice Alito discovered a financial interest in ConocoPhillips, the parent corporation for Burlington Resources Oil and Gas Company. Justice Alito initially decided to not recuse because Burlington withdrew as a petitioner, and with Burlington and ConocoPhillips promising that they would not participate in the case. However, later briefing revealed that Burlington remained a party in the district court proceedings. That was a surprise I discovered by looking at the dockets for each cases one last time before preparing for this episode. Alito's absence increases the chance of a 4-4 deadlock. That would mean Plaquemines would win because they won at the Court of Appeals. Justice Alito likely would have favored Chevron to preserve an avenue for litigants seeking relief in federal court when federal issues predominate over state ones. This makes Monday's oral arguments even more crucial. Let me remind you what this federal removal case really comes down to. The oil companies want these environmental lawsuits moved from state court to federal court under a law that protects federal contractors, specifically people acting under federal officers. The real fight here centers on whether the oil production activities relate to those federal contracts. Here, there's a huge distinction between oil production and oil refinement. In order to refine oil, you have to produce oil, and these contracts cover the oil refinement, but they did not explicitly cover oil production, and this lawsuit centers on oil production. Here's my final thoughts on what to watch for during oral arguments. The justices will likely focus on the gap between production and refinement. Chevron argues that pumping crude oil from the ground relates directly to their contractual obligations to deliver refined aviation fuel. You can't refine what you first don't produce. The parishes counter that the federal contracts never told the companies how to extract oil, only what refined product to deliver. The distinction matters enormously. If the court adopts a narrow relating to standard, requiring explicit federal directives about every single step of the contract process, federal contractors may lose protection for activities performed in preparation of their federal contracts. Defense contractors building fighter jets, for example, could face state court liability for mining the metals used for jets, even though no jets exist without raw metals. Conversely, if the court embraces Chevron's broader approach, any activity within the supply chain potentially triggers federal protection. Farmers growing wheat for military rations could theoretically remove environmental suits to federal court. All right, now let's go to January 13th, 2026, where the Supreme Court will hear two cases, Little v. Hecox and West Virginia v. BJP. For my final thoughts on these cases, I'm going to highlight 2 points. The first is separateness, and the second is mootness. As to separateness, I mistakenly called these cases consolidated, but they're actually not. They're two separate cases involving parallel issues. Let's briefly look at their similarities and differences, and then see what a split ruling can mean. Idaho and West Virginia both prohibit transgender women from competing on male sports teams based on biological sex definitions, but they differ in their language and scope. Idaho law prohibits all transgender women categorically at every educational level from all female sports. West Virginia's law, on the other hand, prohibits participation only in sports involving competitive skill or contract. This distinction may matter. Picture this scenario. A transgender girl wants to join her high school's recreational badminton club. The student would face rejection in Idaho, but could potentially participate in West Virginia. This creates the possibility of a split. If Idaho wins, but West Virginia loses, states could implement broad bans on sports activities using biological sex definitions. But states might need to carve out exceptions for non-competitive activities. Now, if West Virginia wins but Idaho loses, states could maintain targeted restrictions but not implement sweeping categorical exclusions. During oral arguments, expect Idaho's advocates to defend bright-line rules and administrative simplicity. The justices may press them on overbreadth concerns. For West Virginia, listen for arguments about tailored approaches aimed to address specific competitive concerns. Watch for questions about line drawing problems and enforcement complexity. My second point about this case, mootness. Barring a few exceptions, the Constitution permits courts only to hear live controversies, which means active disputes between two or more people. By contrast, the Constitution generally bars courts from deciding theoretical challenges. This prevents courts from issuing advisory opinions on hypothetical problems. Think about mootness like this. A neighbor, Walter, sues to stop construction in their neighborhood. Let's call it Northridge Square. In litigation, the neighbor moves to another state. The construction no longer affects him, and he has no intention whatsoever to move back to Northridge Square. For these reasons, Walter files paperwork to withdraw the lawsuit. The lawsuit becomes moot. There's no more controversy between the parties. Walter no longer suffers an injury from the construction, so no live dispute exists. That's mootness in action. The case should be dismissed because Walter no longer has a live controversy. But let's add this one wrinkle here. And let's say that the judge issues a ruling anyways, even though Walter wanted to drop the case. The judge rules the construction violates zoning laws and must stop. This creates an advisory opinion, a ruling without an active dispute, which the Constitution prohibits. Walter's scenario basically jostles out now in Little v. Hecox. Shortly after the Supreme Court granted certiorari to hear this case, Hecox tried to dismiss it, even though Hecox won at each litigation stage. On September 2nd, 2025, Hecox filed what's called as a suggestion of mootness with the Supreme Court. It's basically a request to voluntarily drop the case with prejudice, meaning Hecox can never rebring the suit. Hecox also filed a request of dismissal with the district court judge. And with the Supreme Court filing, Hecox filed a declaration saying Hecox permanently ceased playing sports covered by Idaho's law. Hecox wanted to focus on graduation without litigation pressures and public scrutiny. In Hecox's brief, the lawyers argued primarily on mootness grounds. They say no live Article 3 controversy exists. Hecox abandoned all present and future claims and stopped participating in covered activities. Little, on the other hand, forcefully responded with a supplemental brief, arguing, among other things, that the case remains active and live because the district judge rejected Hecox's dismissal request. They pointed out how the district court struck Hecox's dismissal as, quote, manipulative to avoid Supreme Court review. See United States versus Scrimetti, which we talked about in our preview episode and in our mega episode. The court also found that Hecox could still change Hecox's mind about playing sports. This finding was based on past experience with Hecox's shifting positions in the litigation. That's a mini rundown on the mootness issue that presents itself in Little v. Hecox. I imagine it will feature prominently because Hecox raised mootness as its primary argument in this case. So during oral arguments, listen for words like mootness, Article 3, live controversy, and voluntary cessation. All right, let's go to the final case heard this week. CSX Gillette v. New Jersey Transit Corporation, consolidated with New Jersey Transit Corporation v. Colt. The Supreme Court will hear this case on Wednesday, January 14th. For this case, remember the central question: whether the state authority enjoys sovereign immunity. If they do, transit authorities cannot be held liable for harm to people. Meaning, for example, you can't recover if the state bus runs a red light and hits you on a crosswalk. Let me add these wrinkles here. New Jersey actually has a specific process that allows people to sue the New Jersey Transit Corporation for these types of injuries. It's called the New Jersey Tort Claims Act, and people have to file their lawsuits in New Jersey state courts. They also have to follow certain procedures that the New Jersey Tort Claims Act requires people to follow. In these types of lawsuits, the Transit Corporation actually cannot claim sovereign immunity. But here, because the plaintiffs got injured in Pennsylvania and New York respectively, they filed lawsuits in those states, not New Jersey. The constitutional tension centers on this conflict. New Jersey Transit argues that as New Jersey's creation, it should get New Jersey's sovereign immunity protection, even when sued in Pennsylvania or New York courts. The forum states, Pennsylvania and New York, argue they should maintain jurisdiction over entities that cause harm within their borders, regardless of where those entities originated. From New Jersey Transit's brief, their heartland argument goes like this: interstate sovereign immunity protects each state from the indignity of another state hailing New Jersey into that state's courthouse without New Jersey's consent. It would be like Europe hailing the United States Department of Justice into a European court, even where the United States did not agree to be sued in European courts. Transit wants New Jersey's characterization of New Jersey Transit as an instrumentality to control the analysis. In that sense, the case isn't about whether a state holds sovereign immunity over this type of claim, but whether a state can control the jurisdictional boundaries of sovereign immunity. The plaintiffs counter that New Jersey's test would allow magic words such as instrumentality to strip other states of jurisdiction, even in cases where the harm occurred in those other states. It's almost the reverse sovereign immunity argument. How can New Jersey restrict what New York can and cannot allow a party to recover injuries for action within those boundaries? This creates the sovereign immunity puzzle at issue here. Does state sovereign immunity include the power to shield its entities from all other state courts? Or does each forum state's sovereignty include the right to hold entities accountable for operations within those forum states, regardless of where those entities are formed? Watch for this tension during oral arguments. Does state sovereign immunity mean the creating controls? Watch for this tension to play out in oral arguments. Does state sovereignty mean the creating state controls the analysis completely? Or does equal state sovereignty require balancing state interests against each other? Also, watch for questions about state deference and the implications of states using magic words. If states can manufacture immunity simply by inserting phrases like, quote, instrumentality of the state into their statutes, every legislature could create bulletproof entities overnight. The justices will likely probe whether constitutional immunity can result from legislative wordplay or whether substance must match the statutory labels. That's it for today's episode. Thanks for listening to the High Court Report. Please follow, rate, subscribe, share, and review the podcast. You can find us on Apple, Spotify, YouTube, LinkedIn. Just search the High Court Report. Questions about a case? Hit us up on LinkedIn at the High Court Report or by email. Talk to you soon.